Introduce myself to those of you whom I haven't met, one or two of you perhaps in the room. I'm Elizabeth Rindskopf Parker, and I'm the fortunate dean of the University of the Pacific, McGeorge School of Law. I'm particularly fortunate this morning because the Ethics Symposium, which is now in its 5th year, is something very special to me, and I hope you'll just indulge me for a moment while I give you some more formal remarks, but begin with kind of a story. This is a symposium that is funded for a decade-long series of events like this one by the Sierra Health Foundation, and we call it Ethics Across the Profession. And you may wonder, possibly, what that title is all about. Well, the origins of this wonderful opportunity that Sierra Health has brought us really came from an earlier dean, Gordon Shaber, who was very concerned about ethics in the legal world, but also ethics generally. And he made a rather significant contribution to Sierra Health, which he hoped that they would match and do something with ethics. And on an occasion, having lunch with the former director, we struggled as to how we would do that, because of course health is not law, although there is a relationship. And we came up quite, what'll I say, serendipity was the theme, with the notion that maybe we should talk about ethics more broadly, not just law, but across the professions. And with that, what shall we say, moment of thought, without a whole lot of planning, an idea was born. And what delighted me subsequently was to learn that we had maybe stumbled into the truth, because as I got into a little bit of research on this, I noticed that Stanford was looking hard at this. In fact, Deborah Rohde was one of our very first speakers at the first symposium we did, and she complimented us on the notion that we were going to look at ethics more broadly. Well, I must say that this is the third of these events that Paul Paton has organized, and there's another part of the story that involves Paul, because I suspect that one of the ways in which we were able to entice Paul to McGeorge, and he is of course a student of Deborah Rohde, was the opportunity to design and further develop this symposium series. And so it's a particularly personal pleasure that I have in welcoming all of you this morning. I do think there's something quite unique about this event, because it does look across bench bar, the academy. It really has gone into a number of very interesting areas, and we intend to do so as we go forward. So before we turn really to the substance of the morning, and I know you have some wonderful speakers here, I'll simply say that I hope that, like all law schools, McGeorge puts a very high focus on ethics. We have, as you may or may not know, an ethics competition, a trial competition annually, and that's another way we look at ethics and try to reinforce its importance. The fact is that ethics is really core to our profession, and increasingly we see as well in the international framework that ethics or culture is really essential to how we understand the way in which legal systems work together, and will be, I think, in the future an even deeper and more important subject for us to look at. So whether we're talking about civil rights or commercial litigation, antitrust, no matter what the field, ethics is going to be core to it in one way or another. And today I think we have a very interesting opportunity to look at it from quite a different perspective. And so, Paul, I thank you for ethics and a new look at the flat world, which I think is exactly the theme that we hope to develop over this decade-long series. And Paul, to you, I express again thanks for bringing such a wonderful group together, and I'd be remiss if I didn't mention our staff. Lily, you're standing in the back, and I know Clemence Kuchera has done great things too. So to you too, thank you for helping us bring together what I think is going to be a really wonderful day. I will have to apologize and say that we have more going on. It's a three-ring circus on our campus today. We have some future students, we hope, joining us, and we're hoping some of them may even spend a minute or two with you at some point during the day, but I'm going to have to leave to greet them in a moment. So I'll stay, but if I leave, it's not because anybody has said anything with which I disagree.
Thanks very much, Elizabeth, and good morning and welcome to everybody. For those of you who don't know me, I'm Paul Paton, a professor of law here and director of the Ethics Across the Professions initiative since my arrival at McGeorge in 2008. Today's topic and theme in terms of ethics, globalization, technology, and the future of the practice of law in part emerges from an announcement in August 2009 by then American Bar Association President Carolyn Lamb, when she announced the formation of the ABA's Commission on Ethics 2020 as she was assuming the leadership of the ABA. And just want to quote from her press release: "Technological advances and globalization have changed our profession in ways not yet reflected in our ethics codes and regulatory structure. Technologies such as email, the internet, and smartphones are transforming the way we practice law and our relationships with clients, just as they've compressed our world and expanded international business opportunities for clients." So that was the launch of what will be a 3-year commission on ethics. I was appointed a reporter to that commission last December and have been more deeply engaged in its work and touched even more deeply, again, by the way in which transformation of client relationships, of what we call a profession, is happening and is happening at light speed. One of the things that came out of the Commission's preliminary issues outline in November 2009 was consideration of how core principles of client and public protection could be satisfied while simultaneously permitting U.S. lawyers and law firms to participate on a level playing field in a global legal services marketplace that includes the increased use of, amongst other things, one or more forms of alternative business structures. So we're looking at a very different market. We're looking at a very different way of offering legal services. And we're also looking at the different technologies that have had a profound impact. Who knew that you could actually pay for and get legal advice by tweet? This was something that people had never considered a couple of years ago. While I'd love to mark examination questions in 140 characters or less, it would expedite the end of term extravaganza that we all face. It's something that, again, carries with it some very serious ethical consequences. So in forming today's program, I tried to reach out, again, to thought leaders in the academy, in practice, in regulatory environments, and to bring them together for a half-day dialogue about these issues. And I'm honored, it's a real privilege to have all of our guest speakers and panelists here, and I'll be doing some introductions through the morning. Our first panel will start off with a consideration of Gillian Hadfield's paper, Law for a Flat World. Now, I've been affected personally in my own writing and research and thinking by Gillian's work on legal services marketplaces. The kind of advanced thinking that she's done, bringing an economic perspective into consideration of professional issues and values, is something that I've used as a signpost to test my own ideas as things are going along. And we're privileged to have Pat Hanlon from a tremendous experience in Washington, D.C. in practice and now at Berkeley to comment on Gillian's paper. We'll then move into an even more radical shift, perhaps, with Renee Knakke's paper, considering whether recent First Amendment jurisprudence means, well, long and short of it, means whether or not others can end up, including corporations, can end up owning law firms. Who gets to own the practice of law? How does that end up working? And then we'll move, after the morning break, into a panel discussion that's wide-ranging on technology. And if technology cooperates with us, we'll actually have 2 of our speakers joining us, appropriately enough, by Skype. And as they're going to be participating in the ABA's tech show, they weren't able to be here in person. Stephanie Kimbrough from the Virtual Law Office has really initiated this idea of law without walls in many respects. Chaz Ramphethal from LegalZoom, considered by many lawyers to be somebody transforming the market, maybe or maybe not in a positive way, but looking at the ways in which clients are accessing legal services and responding to legal needs. LegalZoom has been a leader in both understanding that market and actually responding to it. Dave Belinsky from the Law Society of British Columbia brings both deep experience with the tech issues and also a regulator's view. You know, how do you actually regulate this brave new world? And the matching pair of technology and globalization, I think, are themes that are intertwined. We're looking at the ways in which our graduates here at McGeorge, even our slogan or branding, talks about local and global. we are moving lawyers into an increasingly interconnected world of legal practice, and that carries with it tremendous ramifications for not only what we've considered traditional structures of ethics and regulation, but also for the public, access to justice. So in that broad overview, I'll try and set the stage. I like to describe these symposia as you put the buffet table together, you set the table, and you hope that people come and take part. And so in that respect, we're grateful to all of you for being here and look forward to your participation this morning. Let me do a more formal introduction of Gillian before we launch the first paper. Gillian Hadfield is the Richard and Annette Kirtland Professor of Law and Economics at USC's Gould School of Law. There is a Canadian connection. It's part of my insidious plot. And you thought Celine Dion was problematic. Gillian did her undergraduate degree at Queen's University, where I used to teach before coming to McGeorge. A JD from Stanford Law, MA and PhD in economics from Stanford, so there's a Stanford connection there as well, and taught at one stage at the University of Toronto. Her work is profound in terms of dealing with the design of legal and dispute resolution systems in both advanced and developing countries and advanced and developing market economies. She looks at markets for law, for lawyers, and dispute resolution, contract law, theory, economic analysis of law, and also gender in economics and law. She's the director of the Southern California Innovation Project and a co-director of the Center of the Law in Economics and Organization, and teaches in contracts, advanced contracts, strategic analysis, legal design, antitrust, and intellectual property. This is somebody who's an intellectual giant. And so in that respect, at least, my respect for her work actually goes back to one of her earlier articles, or started in her earlier articles, published in the Michigan Law Review back in 2000, called The Price of Law: How the Market for Lawyers Distorts the Justice System. And in that respect, at least, I developed an admiration for somebody who was willing to ask the tough questions. And I think what you'll see in the discussion this morning and in Gillian's ideas about law for a flat world is that we're getting some tough questions and some pretty tough answers. So Gillian, it's a real pleasure to have you with us here this morning. Thank you very much for coming.
It's a good thing I'm an intellectual giant because I ain't a physical giant. So I usually hide behind these. It's like the Queen. I don't want to wear a hat. Thank you for that introduction, Paul. It was a great intro, eh? Okay, great. Let me get us started here. And it's coming back. Is it coming back? Lily? There we go. You got it? There we are. Okay. So in many ways, when I backed into, I'm an economist. I study law. I don't even think I took legal ethics in law school. Can I admit that? I don't know. It was way long ago. So they still gave me the degree. But I'm not a member of the bar, so I guess that's the grace. So I backed my way into something where people started saying, well, you're talking about legal ethics, because I was studying the economics of the markets for lawyers. The paper that Paul mentioned, The Price of Law, in 2000, that was really the first paper I wrote in this area. And honest, I wrote it because I had to pay a lawyer. And I said, how can it possibly cost this much? What is going on in this kind of a market? So I had backed my way into discovering that actually what I'm talking about is what lawyers in the profession talk about ethics, but in a way that I think really collapses these two categories. So let me start off. If you're sort of a legal ethics person, I think I'm going to, you're going to be slightly discombobulated by the amount of economics I'm going to talk about in the market, but that's partly the point. But have no fear. It's not that I don't care about economics. It's not that I don't care about confidentiality and how clients are treated and so on. But I do think we really desperately need to disentangle these sets of issues. Actually, I think of that as a key component of professional responsibility. Okay, let me give you my answers up front and tell you what the three basic claims I make in this paper are. Is first, that transformations in the economy are transforming what I call the economic demand for law. I'm going to define all these terms in a minute. I'm then going to try to convince you that our existing legal infrastructure, I'll define this term as well, is failing to adapt adequately to meet that economic demand for law in the new economy. So this is the technology and globalization piece of things. And then saying that really what we as a profession produce The legal infrastructure is really not keeping up with the change in the new economy, and I think that's very serious from an economic point of view. And then the main claim here that's going to be of interest from the point of view of ethics policy is failure to adapt that legal infrastructure is in part because we fail to approach policy about regulating legal markets as economic policy. Now, it doesn't have to be exclusively economic policy. I happen to think there are sectors where we could say it's pretty much economic policy. Large corporate clients and so on, I think that's largely economic policy. Again, don't fret too much if you want to sort of say, well, there's a piece of things. What about those criminal defendants? What about family law litigants and so on? That's not saying, but I'm really focusing here on the economic policy piece. So let me define this claim, the economic demand for law. I mean by that, the demand for legal inputs that support the creation of value in economic relations. So that's things like, okay, Paul and I are going to put together a joint project, a joint venture. We're both going to put money in. I want to make sure he's going to do what he says he's going to do. He wants to make sure I'm going to do what I'm going to say I'm going to do. That means we need some kind of a legal input, like a contract, or some mechanism to assure us about our commitments, that we're going to do what we say we're going to do, we're going to get the money out of it that we think we're going to get out of it. So from an economist perspective, it's like a factor of production. It's something that goes into structuring and managing relationships. It's distributing risk. It's securing commitment. It's getting down on paper what it is we said we were going to do. And if you want, I teach contracts, so I'm biased towards contracts. Contracts will serve as a great example for anything I'm saying here if you're trying to get a picture of it in your head. Now, I said that there's lots of things that go on in the legal system, but it's really important for lawyers to come to grips with the fact that the economic sector in law, we don't know exactly what it is because lawyers hate collecting data, so it's really hard to actually do the numbers on this, but I would estimate it. I've done a couple of things based on the Chicago Lawyers study of Ontario lawyers that I've done, but haven't published because lawyers aren't interested in the answer, is that the economic sector in law is probably about 60 to 70% of what goes on in law. Right? That means to say supplying work and legal inputs for people who are doing business, not for criminal defendants, not for family law litigants, not for consumers even in consumer protection. 60 to 70%, that's a lot. And we know this because we know what the career patterns look like as well as most lawyers. And so if you take nothing else away, here's the point. Legal inputs in this sector are economic inputs. They're economic goods and services. If you took Econ 101, they're factors of production. Okay? All right, so that's what I mean by the economic demand for law. Now, what about this other term, legal infrastructure? I define legal infrastructure as the set of legal inputs that's available out there to be deployed to structure and manage economic relationships. So if you've decided to put together a company like LegalZoom, it's, you get together with your co-founders and you look around the room and say, okay, what is it that's available to us to put this business in place and to move it forward? What can we draw on? It's obviously the types of rules that are out there, but it's also the practices. It's what kind of expertise, what kind of advice, what kind of strategies, what norms you would find when you went out there to try and put it together. When you pulled templates off the internet for contracts, if you didn't pay for them, what's out there? What do lawyers say I need? Do they say I need, look, you can't write a contract that's not 15 pages long and filled with 4.2.3.6 and indemnities and representations and warranties. That's what contracts look like. Well, that's a particular practice. And one of the things we know from looking at the development of market economies around the world, right, particularly the transition economies that are building market economies, is part of what they face is a difficulty in the type of legal infrastructure available to them. So it's the whole set of things, and it's the byproduct, the accumulated byproduct of what lawyers do. So this is why how we regulate the market for lawyers is going to affect the stuff that's on the ground for the next generation of businesses and so on to structure what they do. So what we're doing is providing them with what they're going to have available to them in the future. And I call that legal infrastructure because I want you to think about it as the bridges and the roads and the connectors and the stuff that could be crumbling and the bridge that falls down and the circuitous stuff that can't get you from A to B at a reasonable price. So you want to think about it. The other thing about infrastructure, invisible until it's broken. You don't really pay attention to the garbage people until they don't come around. Right? And so that's part of how you find out what's going on with this stuff is you say, well, where is it broken? Okay? All right, so first claim, transformations in the economy are transforming this economic demand for law. Okay, so what are the transformations in the economy? We talk about the new economy. Lots of economists don't like the term the new economy. What do I mean by it here? Why use it here? Well, what's the old economy? The old economy is the vertically integrated economy where, you know, you did everything. You brought in the raw materials for steel, you made it into steel, you pressed it into pieces for cars, you developed, and you got finished cars that come out the other end. Vertically integrated in the supply chain. Mass production, standardized goods being mass produced. From an economist's perspective, it's an economy that's dominated by thinking about scale and scope economies. I'm really, really pressing on that Econ 101 years ago, aren't I? Right, the idea that we can reduce the cost of products by increasing the scale on which we produce them, and sometimes, and this is like the conglomerate, putting together different types of products because we can produce complementary goods more easily. There's no test after this. It was predominantly, the old economy is national markets. Sure, we've had companies involved in international trade for you know, hundreds of years, but it's nonetheless, it's been predominantly a national market, and not like, you had to get big to be part of the international market. When you got big, you got into the international market. And relatively stable. Yes, we had interest rate fluctuations and price fluctuations, but for the most part, you could say the business is not going to look too different 5 years from now. Okay, so what have we got? What have we got today? The new economy. Now, clearly, this is an overstatement because lots of the stuff on the left-hand side of this screen is still going on. It's really, really very important. Don't read this as, oh, but wait a second, I've identified a vertically integrated firm. You know, you can't be right. That's not the point. The point is that what we see emerging in the new economy is a very different structure. We see lots of networked entities, right? So we actually, economists talk about de-verticalization, right? The horizontal. In fact, this is, if you read about, we've been hearing about global supply chains with the Japanese earthquake and tsunami, right? The disruption and the fact that, well, a lot of parts, you got zillions of parts in a lot of our products and so on today, and if, you know, one place in the chain can't produce the part, then you can't produce the thing. And if you look at a map sometime of where a Dell computer gets produced, for example, is this a Dell? Yeah, then you know, it's basically just scattered across the globe. All of that's connected, that's networked. Web-based production, a lot of that is taking place on the web. Data is being stored on the web. You've got cloud computing, right? That's become a new platform for getting work done. We're actually doing a lot of the production on the web. Heterogeneity, fancy word for lots of things. It's not standardized, right? I've got my little mini out in the parking lot, right? You know, I could go online and I could say I want this color and I want this stripes and I want the flags, or I don't want the flags, right? Even buying a car, I can go and kind of design the little car I want. But we have a lot more capacity to produce non-standardized goods. Those of you who might have heard of Chris Anderson's book, The Long Tail, and the idea that, you know, now you don't have to just buy the blockbusters. If you want the, you know, the oldies special, you know, some tiny recording from 1973, you can find it because there's 1,000 other people just like you, oddly enough, and you all want it, and we can put it together. We still have scale and scope economies, absolutely, but we're now becoming an economy where information and network economies are really very important. And from an economic point of view, those have a significant effect on the way markets organize. That's why we get mega, you know, we get Google, we get Microsoft operating systems. Those are a consequence of information and network economies. I won't belabor that point too much. Either you know what those are, or it would just slow things down to try and say. But anyway, it looks different. It looks really different. Global markets. We're not just national. We're global. And as some of the general counsel I spoke to when I was doing this project said, you know, it's no longer you just get big and then you go international. A lot of these companies are global from day one, right? The day they opened their doors at some Silicon Valley startup, they had a programmer in Bulgaria, right? They've got somebody, they're international from day one. And stability is a thing of the past. It's an environment of rapid change. We don't know what it's going to look like. Does anybody want to predict what we'll think about Google in 5 years? I don't. And a lot of it is emergent, which is to say, because it's network-based production, we don't know what it's going to look like. Nobody knew what Facebook was going to look like 3 years ago, right? Don't know what it's going to look like a few years. And we all know there's something we've not even heard about, right? That nobody's really sitting down and designing. It's just going to be there. So that's what I mean by emergent. Okay, so if you're, want examples, old economy is Ford 1951, and the new economy is Google 2011. If you like pictures, here's the old economy, and here's the new economy. Okay, so that's all you need to remember. So how is the economic demand for law? How is the economic demand for law changing? So what have we got? We've got increased firm boundary crossing networks, lots and lots and lots and lots of contracts, right? We're not just bringing stuff across the boundary of the firm in raw material form, converting it to its final product, and then selling it in the final goods market. We're doing collaboration, we're getting a global supply, lots of firm boundary crossing. Increased jurisdiction crossing, that's what it means to be globally networked like that, global supply chains. It's not all just happening in one legal regime, or even when it's on a state basis, a legal regime where we have a pretty good way of working out what happens if we're in California, but we contracted with people in New York and we built the stuff in Minnesota. Increased jurisdiction crossing. More pervasive and complex transactions and information, and transacting over information is extremely difficult. How much do I want to pay you for the idea that you tell me you have that's going to make my company fantastic? Well, I don't know how much I want to pay you until you tell me what the idea is, but then once you tell me what the idea is, I don't have to pay you. Very tough to contract over information. And people can steal it later. Faster depreciation of legal solutions. When things are changing quickly, you may come up with a great employment policy for this company, and then 2 years later it's completely reconfigured, right? It's not going to last as long. It's not stable. The legal solutions, those things that lawyers are helping people put together as a way to deal with risk, as a way to deal with commitment, and so on, a year later they don't work, right? Anybody who's done any work in contracting knows, in fact, by the time you got the thing written down, the business models moved on dramatically, and you're kind of always playing catch-up. In the entertainment industry, right? They barely get anything written before the film is in the can. I imagine there is no can anymore in the film industry, but you understand the point. Increased differentiation of demand, that is to say it's not everybody's doing sales law, 19th century sales law, which I used to teach at the University of Toronto. Okay, title, insurance, delivery, all those good UCC things, right? That was kind of contracts, and you learned all that, and it was kind of an off-the-shelf thing that worked everywhere. But now people are putting together joint ventures and research and development collaboration, and outsourcing of this piece of the product, and so on. So it's a much more differentiated world. There's many fewer off-the-shelf solutions. Lower tolerance for legal costs. What I mean by that is lower in the sense that if you've got, it's not going to be as valuable for as long. If you've got more competition, if there's more uncertainty, you can't pay as much for it, right? So this is just the consequence of increased global competition generally. And then greater demand for integration of legal and business expertise. That's because you can't do it with standardized solutions, right? All you need to do is learn the UCC if you're going to do a lot of commercial law or sales law for a company. It's all kind of built in there. You don't really need to understand a lot about the risks of insurance and all that kind of stuff. But if you're creating something new, you need to understand it. And that means you need to understand the business perspective as well. There's a real demand for that integration. Okay, what was my second claim? That the existing legal infrastructure is failing to adequately adapt to meet the economic demand for law in the new economy. Okay, so how do we know it's failing? Because none of us want to think it's failing, and you may not even believe me after this, but here's the things we can look at. There's a little bit of data. It's the legal system. We do not have much data, so we just don't have it. We have the fact that we have significantly increasing costs in law that far outstrip the rate at which costs in other sectors of the economy increase. So if you ask large corporate clients, they'll tell you their law costs in the last, say, between 2000 and 2006 increased 75%. The rest of their cost structure went up 20%. It's really, really different. A BTI consulting study, 68% of large corporate clients would not recommend their primary law firm to anybody. And they're backing it up. 61% replaced the primary firm in the last 6 months. They're not happy. 80% reduced work to their preferred provider between 2003 and 2006. This is from a study that David Wilkins and others at Harvard have done. Okay, so that's the little bit of data we got. What else? So I, in part of this project, went around and talked to a lot of general counsel in large innovative companies, large and small innovative companies, including Mozilla, and these are the types of things. I'm going to rip through these really fast, but the paper's on the website if you'd like to go read a little bit in more detail. Mozilla telling us, look, there's a huge DNA gap between our lawyers and us. Our lawyers don't get what it is we're trying to do. Talking to Mark Chandler at Cisco, complaining about, say, in litigation context, that people who are doing litigation strategy in law firms just don't understand how that syncs with business strategy. That there are things you don't want to do in litigation strategy because it's going to have an impact on the investor community. It's going to have an impact on the PR. It's going to have these effects that you can't think about it in a bubble, right? We're lawyers. We like to think about it in very clean terms. What's the best thing? You know, should we bring that motion to dismiss? Should we fight that? Should we produce that document or not? Thinking about that in a much more way that's integrated with business strategy. That's one complaint. Both Google and Mozilla were talking to me about transactional frictions, just too much of the wrong thing taking too long. Documents that are too long, review that's too long. The pace is incredible in these environments, right? They don't even want to stop for like half an hour, right, to get this down. But when they have to wait a week in the process of putting this thing together to get legal to look it over, right, things fall down by the wayside. Kent Walker, who's GC at Google, talked to me about, you know, how do I figure out how to incentivize my lawyers in-house to realize that sometimes they're killing deals, right? I can recognize their work when they do a great contract, but what about the things that got away because they took too long, they insisted on too much detail, and so on, and they were paying attention to the wrong things. There's a patchwork of providers for the global firm. We do not have truly integrated international legal representation because we have these barriers, these regulatory barriers, not only at every state boundary, right, but every country boundary as well. So you really can't get the global firm. Hard to find providers because of that with solutions to what I call wicked global compliance problems. In Google's case, one example of that is YouTube. You know, you roll out YouTube in 100 countries at once, defamation law, privacy law, obscenity law, security, encryption, a whole bunch of stuff. It's out there simultaneously. How do you deal with that? There's nobody who can put together a unified solution for that because that's not available in our legal infrastructure. Risk aversion, we've heard about that a lot for a long time about lawyers. Sometimes it's a good thing, but an environment where risk is just, you know, that's the meat and potatoes of the day, or the sushi, I guess. You need lawyers who are comfortable with this, who understand risk. CBS Television, John, a financial general counsel there, you know, talked to me about, look, he had to finally, you know, get rid of a certain group of lawyers because he walked in the room every single time saying, it's really risky. Are you sure you want to do this? I don't know if we can protect you on this. And he needed people to say, look, we have to move forward. Yes, it's risky, but there's no way we can't move in this. And when you're right, we have no idea what it's going to look like. But we still have to figure out a path forward, and we need lawyers who are comfortable with doing that. Okay, so the other way, the other base in which I would defend the claim that we know it's failing or we predict it's failing is my favorite because I'm a theorist. Theory, you know, you just have to look at it and say, what have we got? What does the legal infrastructure we have look like? We have lots of complicated, esoteric, text-based rules produced through replication. How do you draft a contract? You find one that looks like it, and you mark it up. You change stuff. And of course, you've heard about the experiments where people have buried stuff in there and nobody's noticed. It says, you promised to do my grandmother's laundry every Thursday. And you know, these kinds of things actually can persist forever because there's really nobody. Linguists call it frozen, right? What you see in contracts. Now, I don't want to be too harsh on lawyers. There's some of that complicated, esoteric stuff is good and important, and we're not throwing it out. But I bet a lot of people who are doing it don't actually know how to figure out what it is, which of these pieces they want, and which they don't. But we have this is our production method, right, to reproduce that. And what does it do? It gets longer and longer every year, right? Happens in statutes, happens in regulations, happens in contracts. That's a very, very tall order for the kind of world I just described to you. The one that's changing rapidly, lots of uncertainty and so on. It works great in the 19th century, maybe even the first half of the 20th. We have human capital intensive craft production. What does that mean? That means that we solve problems on a craft basis, right? And that's our model of legal work. You know, you've got your problem, you come to my office, and we work on that problem, right? We don't use large-scale data analysis. We don't use enough of the kind of techniques that LegalZoom is working with. We're really focused on the idea. It's human capital intensive. It's one client, one person sitting in a room. What's your problem? Let me get out the yellow pad, and we'll figure that out, right? That's our production method. We have undiversified production models, and I mean this in two ways. Undiversified in human capital, which is to say most lawyers work with other lawyers. They're not sitting around the table very often with the engineers and the finance people and the strategists and the communications folks, right? They work in almost exclusively lawyer-dominated environments. They go to school with lawyers, they work with lawyers. Even when they go to the client, the corporate client, they're working with the lawyers there. Lawyers are talking to lawyers all the time. And homogeneity is not great for innovation, right? So it's an undiversified idea pool. We also have undiversified financial capital going into the legal markets because it's lawyer-only financing. That's what it means to say you can't have outside investors or fee sharing with non-lawyers, right? You can get bank financing, which we know what that problems that created for some of our big firms recently that saw a lot greater uncertainty, and they're great firms, great brands that disappeared because that was a very fragile financial model, and we don't have diversification there, and little competition. Okay, so failure drops in part because we fail to approach policy regulating legal markets as economic policy. And again, cabin this off and not saying there aren't things that we definitely have lots of other interests in, but as I said, maybe 60 to 70% of the market we're talking about here. And in this setting, legal ethics is economic regulation. It's express supply constraints, restrictions on non-lawyer providers, geographical constraints, say California bar, got to practice in California. If LegalZoom has to worry about who's using the documents, right? JustAnswer.com has to worry where's the lawyer located and the person who's asking the question, which is just mind-boggling in the world of the internet. We have constraints on capital. That's the investment point. We don't have venture capital in law, right? You can't get you can't even go to your friends and family, right? Those who worked when they started. You can't go to your friends and family and say invest in the business here while I get started. Right? Because that's a source of capital you can't use. You can't have venture capital and risk diversification. Risk diversification is really important if you want to move away from hourly billing. You want to go to project-based billing, flat billing, that's a different risk proposition. You need to be able to smooth that risk, right? But we don't have diversification of that, and no diversification of human capital, and that produces a low rate of innovation. This is just the economist talking. It says if you take all of these features and add them up, what you have is what we've got, something that just stays the same, largely. I don't want to underestimate the things people are doing. There are people who are clearly trying to press the envelope. And then there's stuff, I mean, I know there are things that look different in the firm today than they did 50 years ago, but not a whole heck of a lot about the way we're getting stuff done. So low innovation in demand, and innovation on cost, innovation on what it means, how you accomplish meeting that economic demand for law. If Paul and I need commitment services to support our joint venture, where could those come from, right? Law is one of the ways we can do that. With a contract we can do that. Maybe there are other ways. We're not working that forward. So I guess my message is that we should be thinking about, again, in this economic sector, regulating law like other markets. What would that mean? Well, it's actually pretty easy. I'm sure you already know. Open legal markets to competition. That means reduce, eliminate, I would have said eliminate, but I thought I should say also reduce, unauthorized practice of law restrictions, multidisciplinary practice restrictions. I've heard something about what's going on with that. I guess we'll hear more. And allow the emergence of multiple professions so that we have a competition between different professions providing legal services. There's nothing wrong with professional ethics and professional organizations that say, you know, if you wear the label of a member of the bar, here's what you get, and we drum you out of our organization if you violate our principles. But you don't take that up and say, and everybody who wants to provide this service has to wear this label, right? In fact, if you think you're providing something that is a much higher quality, you should be quite happy to get out there and compete on that. expand the scale of practice. We're in a world that just can't, where scale is very important for data analysis and so on, and this involves things like reducing or eliminating multi-jurisdictional practice restrictions. I think we should be talking about a national licensing scheme, which would, you know, you could have an opt-out version. You could have a version that says if you got large corporate clients, you want to be nationally licensed, here's just a different, lighter framework. We know all of our consumer protection issues are very different in that context, but that's the world in which we're operating. In fact, we should be looking for, globally as well, opening up to international. And of course, American lawyers are thinking about this a lot now because they're saying, wait a second, we don't like the fact that India won't let us open up offices there. We have lots of clients that want to do business in India, and we want to service those clients. We want to work for the Indian firms and put that together. Can't do it right now, right? So we clearly have to be headed in that direction. In some ways, I think it's a bit redundant for me to give the talk because I just can't imagine that we're not going to be there in 10 years, right? Maybe sooner. Hopefully sooner, right, Chad? And increased financial and human capital diversity. Now that's reducing and eliminating restrictions on corporate practice of law, on what we call fee sharing, which is simply outside or non-lawyer money into the business to support it. Now, I've written at the end here, it looks like it's a bit cut off here, that's not important. Increase consumer protection. If our claim is that legal ethics is about protecting people, right, protecting the users of law, then let's get serious about that. Focus on that. We actually don't do a very good job of that, right? We actually restrict malpractice. Much harder to bring a malpractice claim against a lawyer than anybody else in the professions. Professional ethical standards are much, much tougher for the plaintiff in a legal malpractice. We could look, you know, we got statutory provisions that can protect clients. We got antitrust. The rest of the world, UK and Europe, are really serious about antitrust applied to the professions, including law. And that's another way in which the profession here is protected. And I just couldn't fit it on, I guess. Ethics. There's nothing wrong with having strong ethical standards that really are about ethics and how we treat clients, disciplinary proceedings, and drumming people out. But I really think that for a lot of this, we need to recognize it's about economics. Thank you.
Sure. Thank you very much. For the first response, I've invited Pat Hanlon, who, as you will see from the materials, is lecturer in residence at Bolt at Berkeley. Pat is deeply engaged now as an academic in work that he had deep experience in for more than 30 years of practice in Washington, D.C., specializing in complex litigation, toxic tort cases, and now teaching professional responsibility and these other issues. He's on the edge and looking at the interaction between professional culture, regulation, technological change, and comparative approaches to the regulation of lawyers. And so in that respect, at least, I could think of nobody better to start off with the first response to what Gillian's presented.
So this isn't going to be a very global response because in a global way, I more or less agree with Gillian. And I think that if you concentrate a little bit on the last 5 minutes of what Gillian said, there's a whole program there that goes way beyond the question of new economy and adapting to the needs of the new economy for private ordering and for changing the way we go about doing private ordering. And there's an underlying thesis, which is a bigger thesis, which is essentially applying that we might be a little bit better off if we allowed law to be more of a business and welcomed that and looked hard at the things we call, quote, profession, because some of that doesn't involve protecting consumers, some of it involves protecting lawyers and protecting lawyers from threats that may not actually exist. And so I actually endorse practically everything Gillian said, and from my perspective, which is a very different perspective that comes from 30 years of practicing law, it all seems to fit, which suggests that wherever you start from, you still seem to come to the same place, which is that the regulation we have of the structure of law is not really very satisfactory in dealing with a whole wide range of problems, and not just the problems that are characterized by avant-garde companies like Google. So if you look more carefully at what Gillian just had to say, there are two things that stick out at me that I'll quickly emphasize because I think that they're especially important. One is the notion that what regulation is to a considerable extent, to a predominant extent, a matter of economic policy, and it should be evaluated with the way we evaluate other economic policies. That's an idea that we should grab onto and say to ourselves in the morning when we rise up and in the evening when we go to bed, and put it on our doorposts, because we really need to remember that it's not about us. Secondly is there's not much research in this area. What we've heard is a lot of stand to reason stuff, which I doubt a little bit in some respects, but basically it's a sort of, this is what one might expect if we understand what the structure of the new economy is. And the new economy, for me at least, breaks down into at least an avant-garde, for which is dominated by new economy ideas, and then a lot of new economy things are integrated into an older economy, including that local economy that is served by the 49% of lawyers that are still solo practitioners. And in fact, which may increasingly be served by people who, like LegalZoom, who are making things available on the net and giving people an opportunity to be their own lawyers. So I think that it would be really helpful to understand better why we do have the dissatisfaction we have. Obviously, sticker shock is a big part of it. Is this a bigger problem for avant-garde firms? Does it have to do with the specific things that relate to their business, or does it relate to more to firms generally? A lot of pretty old guard firms or old guard companies are complaining about their lawyers. In fact, practically everybody is complaining about their lawyers, and I'm ready to do that too in a minute. It would be really nice to have I mean, of course, every symposium at a university is going to call for research, but it would be really nice to be able to take what Gillian has done and make it deeper and focus on testing the notion that an essential problem is the inadequacy of legal infrastructure to meet the needs of the new economy. But not being in a position to do that right now, I want to pass to a couple of other points. One is, I think that you need to go slow on worrying about the disinclination of lawyers to accept risk. And Gillian put some red flags up. She mentioned a couple of times in talking about this, well, this is compartmentalized, I only mean it in a certain area, but it really is hard in reality to compartmentalize it. There is a mismatch between clients and lawyers in their appetite to risk. That's one of the reasons why it's a good thing to hire lawyers. And in fact, the new economy firm of the 1990s, you'll remember, was Enron, that was doing lots and lots of very, very innovative things, taking lots and lots of risk. After the train wreck, the people generally have a much lower appetite for risk than when they think that's such a great idea. I had a friend who was a general counsel at a large global firm, and one day when we were having lunch, and it was after a couple of glasses of wine, he said, you know, you'd never imagine the things I have to tell them they can't do. And it's good that he should tell them that they can't do that. There are some things that they should say, but of course we have to do these things. This is our business. But sometimes people who have a taste for risk, which entrepreneurs tend to do, are impatient of restraints that are there for a good reason. And we wouldn't want to have lawyers too much imbued with the ethos of risk-taking that's characteristic of the entrepreneurs, because you miss one of the balances in the flywheel that make firms, that keep firms from going off the deep end. So I'd encourage us to be careful about establishing as an objective integrating lawyers more into the ethos of the non-lawyers. There are dangers there, and you have to step carefully, and you can't make them go away by saying, well, there are compartments and you want to be, because figuring out which compartment you're in is not always self-evident. Secondly is that part of the problem of the new firm, the new economy, is dealing with ever-changing relationships where there's not enough of a precedent. And that creates a new set of things where you can't use your accumulated forms. Now wasn't invented in the 21st century. There are a lot of complicated things that require constant adjustment. And a generation before, in the area which I guarantee you did not look like legal practice today, in the construction industry, as people began building huge buildings, they began working out ways of doing this. And the way they went around doing it, which has become the basis for Atul Gawande and the WHO's checklist manifesto for organizing surgery, is by having checklists that identify when things are not right and ways of getting people together to talk about it when suddenly the signs are there that the project isn't going the way it's supposed to be. Now that's pretty old economy stuff. It's like where you have the plumbing where the elevator is supposed to be and that sort of thing. But that's the only way you make a complicated problem manageable. The lawyer, I completely agree that our instincts are to try to solve everything up front. So you have a contract that's so big that nobody can understand it. It looks a lot, incidentally, like the Global Book Settlement, which I challenge anybody to read and understand, and that's a new economy kind of thing. But regardless of that, sometimes you can't solve everything up front, and you have to develop processes for solving it, and the processes have to do with knowing what things are stable, like maybe your confidentiality agreements, which are standardizable or more or less, and what things are variable, and when you have to sit down and talk and arranging that process. Lawyers have done that in the past. And it's not necessarily a thing that has to be done by lawyers. It just has to be done by somebody. So it's conceivable that that is a way in which we ought to be doing a lot more than we're doing right now, and that lawyers ought to get a lot better at it. But for a lot of other things, we need to have more standardization. What LegalZoom is doing is attending to that part of the market. I promised I would complain about my lawyer, who's a lovely person, and she's very good. But I moved from Virginia to California, and I had my will examined, which I should have actually had my head examined, and ended up spending several $1,000s to be told that actually no work needed to be done on my will because the Virginia will worked perfectly fine in California. And I was not being ripped off. That's the way the legal system is, right? And if I'd had more familiarity with LegalZoom, I might have been able to solve some of those problems myself. After all, I have a law degree, although I have no idea what I'm doing in terms of trust and estates. But part of what you need to do, and this I'm sort of linking in with another brand of futurology, what Richard Susskind is talking about, is diminishing the amount of bespoke work, the kind of thing that's structured for this particular problem, and being able to commoditize more. And that means using some of that intellectual capital that's standardized and understanding when it is you're supposed to use it and when it is you're supposed to not use it. In order to make it cheaper for me and for all those counsel who are complaining about their bills, you want to be able to do something like that. So it's a more complicated mix. But at every point along the line, there's a challenge. So the last challenge I want to say is there's something very old economy about the notion that law firms ought to be integrated at the very time we're moving to networks in practically everything else. It may be that the right answer to the instantly global problem is not to have a law firm that has an office in 130 countries, but a law firm or maybe one or two law firms that can put together a network of other law firms that do have presence in those countries. And it may very well be that you should be creating virtual law firms through that change, depending upon what the problem is. And the boundary between the law firms, outside law firms, and the client may also be a porous boundary. Remember, the general counsel are lawyers too. What happens in the general counsel's office is not something that's the company versus the lawyer, it's a different part of doing the lawyering. And it may very well be that having a richer way of dealing with networks and putting together problems is a lot better than having more integration and being able to do integrated solutions by just going there. Obviously, that becomes a question of what's the cost of management, what's the cost of putting things together, how much needs to be pre-positioned and so forth. But it's a world we're just barely beginning to understand. It's also, and this comes back to my very last point, which has to do with close relations between lawyers and their clients. You know, when I started practicing law in the 1970s, that was the predominant thing. You represented you were the general counsel of the client. The outside firm had a specialty of understanding the needs of a particular client. What happened after that was that the general counsel's office grew, and the lawyers who worked in-house were the ones who had the detailed knowledge of the clients, and they also proved to be fickle lovers, and they kept firing their outside law firms. So it doesn't, it doesn't pay a lot of attention and a lot of sense to learn intimately the habits of your partner if you're not going to see him or her tomorrow morning. So the law firms began to evolve away from that. And I think what you're seeing now is a discontent in firms at how much their in-house capability is, and they're beginning to ask for the network from their outside lawyer to work more inside the firm and get a better sense of what their DNA is. Now that could be things like seconding lawyers from your outside firm into the company so that they really get a feel for what the company is like. There are a lot of solutions to that, but those solutions don't work if the next day you say, I'm getting rid of you as my primary law firm, because nobody's going to invest in doing that. So there has to be new patterns, and the new patterns are going to involve new deployments of who's doing what and how you organize things for particular occasions, and that doesn't necessarily, and who knows where that's going to be, which is exactly why Gillian is right. If the answer is who knows, then you shouldn't have the bar arbitrarily limiting the possibilities, because after all, who knows?
I get to bat cleanup, and conscious of time as well as the scope, I want to make two key points. The first is, I think what Gillian's identifying harkens back to, in the ethics context, the law as business versus law as profession paradigm. We have had that, to a certain extent, while she's identifying new issues, old economy, new economy, that law as business, law as profession paradigm has bedeviled the profession back 100 years. And in that respect, that's something that lawyers have never adequately worked out, because we're both. And those who need any evidence of that, understanding completely the lack of data that Gillian referenced, need only look at the economic downturn and the impact of the economic downturn in particular on law firms and on legal practice. Here in the Sacramento area, we're seeing that in a depressed legal services market. The collapse of major firms, Howry most recently, others before it, points towards a consolidation in response to what's going on in the economy. Lawyers are no longer immune. So in that respect, at least, what I respect about what Gillian's identifying from an economic perspective is the reality that's facing the profession, but one of the things on an ethical side that we need to resolve is how can we maintain professional values and not use them simply as a bulwark against competitive instincts. Because so much, and I've articulated this in previous work that I've engaged, is that the legal profession has relied too often on core values rhetoric as fundamentally anti-competitive policy. And that's dangerous. That's dangerous in particular when you're looking at the ways in which lawyers are regulated and who's going to regulate them. And that leads me to my second point. A couple of weeks ago, I was on a panel with the chair of the New English Legal Services Board and the director of the Australian National Legal Services, or Australian National Profession Project, talking to a group of Canadian regulators about the future of self-regulation and the independence of the profession. There has been profound transformation in England and in Australia in the ways in which lawyers are regulated, but also the ways in which people are conceiving of the legal services market. And the two have gone hand in hand. But over a period of about 20 years, through different flavors of government, I point to a combination of scandal, a lack of consumer focus. There's usually always a really good, juicy lawyer discipline case that whatever regulatory body is responsible for has badly mishandled. It always starts there. As a former chair of the Canadian Ontario Securities Commission said, we are about one scandal away. So you have a combination of scandal. You have pressure from national competition authorities. In England, it was the Office of Fair Trading in a report in 2001 that basically said this is a fundamentally anti-competitive profession and we need to open the marketplace. And legal profession, if you don't do it, government will step in and do it for you. And you may not like the result. So you have a combination of consumer scandal, consumer perspective, and competition authorities weighing in, and most importantly, political will. That dialogue that happened here in the United States with the SEC post-Enron around increasing SEC regulation of lawyer conduct was a red flag about the ways in which here domestically we're going to be looking at the traditional manners in which lawyers are not only offering legal services, but how that market is to be regulated. And so in that respect, at least, what Gillian's laying out is very much a global story. But we are not immune from what's going on internationally. There are US lawyers and law firms participating in those international marketplaces. You have a US firm that has established a new form of LDP, legal disciplinary practice, in the UK. A story this week, the DLA Piper, now a US-UK firm, is seeking to add a Canadian wing to its Australian wing and become a worldwide firm of 4,000 lawyers plus. We are no longer bowling alone. And in that respect, at least, it's a time of profound change and uncertainty. What you can often see is people then retrenching. And what I fear is that despite the pressures of the new economy, people are going to look to those old models, simply rely on core values rhetoric that they've used in the past to try again justify an absence of change. I think we all deserve better, and in terms of establishing the dialogue, the work that Gillian's doing and that Pat's referenced are all part of that new story. Gillian, last word to you.
Oh, well, this has been very helpful. Are we going to do questions from the audience? Because I won't take any time for, other than to say on risk, a very helpful comment, Patrick, on risk. It is, the point is not necessarily eliminating, changing the aversion to risk, it's thinking about risk. It's being able to analyze risk, identify what's a criminal law risk, what's a risk, a market risk, and being able to think about risk. And it's the treatment of risk as we've identified a risk, we have to eliminate it. That I think is a problem. But that was very helpful. I appreciate that.
We have time for a couple of questions. I know we're past 10 o'clock, and with your indulgence, we'll run a few more minutes before our break at 10:45. But are there any questions or comments from the audience? Mark.
Just a quick one. You mentioned that obviously the new economy has not displaced the old economy that still exists. It really is overlaid on it, and some companies completely embrace the new economy, like Google and others basically have an overlay of the new economy on the old economy. How does that relate to law? In other words, how much of this problem can be solved by completely new directions in law that break through all the barriers of the old, and how much can be an overlay on existing law infrastructures? As an example, like UCC, for example, is successful in that almost every state has adopted most or all of the UCC, so therefore that has homogenized commercial transactions to the US, or TRIPS for international IP law. How much of this kind of new law can overlay on existing infrastructures?
So I actually think, I think it's right that there's lots of areas that we would describe as old economy, but and Patrick, I think maybe makes a remark like this, is that there, even in our most traditional, like a local economy, somebody who's a real estate agent, right? They're probably using software. Maybe they want to use LegalZoom. Maybe they want to use, there's lots of new economy tools that are integrated and that are still creating those kinds of issues. Now, you may not have the same rapidity that says we need the much more, I'm not sure. Oh,
maybe you.
That's not mine. No, I don't know whose that person is. Not mine.
This would be our dean. And when the dean is calling, one is cautious about answering.
So I think it's partly that, what are the solo practitioners and that slice of the, would emphasize very huge part of the market, right? They're the ones who are competing with the document providers, the one-off legal questions answering and so on. So I think all of that integrates into all of that, and that segment of the market is going to need to figure out what it is that it's providing that's creating value. That it, when Patrick describes a couple of $1,000s to get the answer that my will is just fine, right? That's where we started saying, look, this just really isn't sustainable even in that part of the world. So it's come out of the clouds, we don't have to be up in the clouds with Google. We can just be talking about that kind of even individual services. I steer away from that when I talk about this because there are very different consumer protection issues in that context, and I don't want to minimize those. I would say deal with those separately. But I do agree. I think it's actually much more pervasive. So if we're talking about the cost part of things in particular, we were way out of step, 10, 15, 20 years ago, and we really need to address that. We see that in family law, we see it in immigration law, we see it in housing, and that's where, again, the models from the UK would say non-lawyer providers in specialized firms with standardized procedures and expertise in particular things do a better job than our, the solo practitioner who's doing tax today and criminal law tomorrow and family law next week. Right? And that shouldn't be threatening. That should be, if that's the kind of work you want to do, there are better forms and more productive forms in which to do that.
Patrick, do you want to respond?
No, I think that's what I would have said.
Other questions or comments? Thank you all very much for a provocative, interesting, and important start to the day. We'll move to the next panel, but please join me in thanking Gillian and Patrick for their remarks.